XRP Future Millionaire. It's Monday, August 14th, 2023 at 2:40 p.m. Eastern Standard Time. This is some news from Attorney John Deaton, just some things that are being circulated, and I like to keep everybody informed. So John Deaton says XRP transactions aren't securities even if court certifies SEC appeal request. And this is from today, August 14th, 2023 by Lily Jima. And Attorney John Deaton says even if Judge Therese certifies the SEC's appeal request and stays the Ripple lawsuit, XRP transactions cannot be deemed as securities. Prominent crypto lawyer John Deaton has continued to clarify issues bordering on the non-security status of XRP. In a recent tweet, the vocal attorney highlighted a misconception about the fate of XRP transactions if the court grants the SEC's interlocutory appeal request. A news outlet noted that if Judge Annalisa Therese approves the SEC's appeal request, most XRP transactions might still be securities transactions. That is completely untrue, but that's the mainstream narrative. That's why it's very important to get all the actual facts. Deaton reacts, and you'll get a lot of it in here. Reacting Attorney Deaton noted that that is a false claim, adding that it constitutes total FUD, fear, uncertainty, and doubt, exactly what I was pointing to. According to Attorney Deaton, even though Judge Therese decides to certify the SEC's interlocutory appeal and stay the Ripple lawsuit, it would not imply that most XRP transactions are securities. That would assume just because the SEC claims it is, means it is. That's not even close to being accurate, he added. And then John Deaton shared this. So we can read this as well. And this was shared right on August 11th. It would not mean most XRP transactions might still be securities transactions. That would assume just because the SEC claims it is, means it is. That's not even close to being the case. Here is the truth. As the SEC admits, Judge Therese was the exclusive forum to test the validity of the SEC's claims. She tested the SEC's theory and rejected it with what the SEC claims is a security is not the law. So the case could ultimately escalate to the Supreme Court and remain unresolved through 2025. And then this is what he pointed to. Commission's complaint against Ripple clearly exists. The Southern District of New York will decide whether the complaint warrants any relief. Thus, the Commission's enforcement proceeding in the Southern District of New York, brought under the Securities Act, supplies the exclusive method for testing the validity of the Commission's complaint against Ripple, 15 U.S.C., providing for court actions to enforce the federal securities laws. And see, and then it just tells you to see Breacher 716F. So that is what he's pointing to. So now we can continue reading this. SEC claim is not the law. Let's see. Let's just make sure we... So SEC claim is not the law. Furthermore, Attorney Deaton shared a document showing the SEC admitting that Judge Therese was exclusive forum to the test validity of the claims, and that's what we just read. The pro-XRP lawyer added that the judge tested the SEC's theory under Howey and rejected it. Deaton asserted that whatever the SEC claims is a security is not the law. SEC requests interlocutory appeal. It is worth noting that the SEC has been signaling plans to appeal Judge Therese's ruling on Ripple sales of XRP to retail investors. Last week, the regulator took an official step by requesting permission to file an interlocutory appeal. Notably, the SEC's appeal will focus on Ripple's programmatic sales of XRP on secondary markets and other distributions, as the judge ruled that both transactions do not constitute securities. According to the SEC, the decision on Ripple's XRP programmatic sales poses controlling questions of law on which there is substantial ground for differences of opinion, as reflected by Judge Jed Rakoff in the SC vs. Terra case. It can be recalled that Judge Rakoff had rejected Judge Therese's distinction between institutional and retail buyers of XRP. Per Judge Rakoff, the Howey test does not distinguish between the types of buyers that Judge Therese drew in the ruling. Apples and oranges when you refer to those cases. Pro-XRP lawyer says Judge Therese didn't err. Judge Rakoff's remark has put the Ripple ruling into question, with many suggesting that Judge Therese erred. That's a lot of misconception as well. However, pro-XRP lawyer Bill Morgan shared a document showing that the SEC was responsible for distinguishing Ripple's XRP sales into three categories: programmatic sales, institutional sales, and other distribution. Per Morgan, Judge Torres follows the SEC's categorization of Ripple sales and applied the Howey test to them reacting. Deaton said he is willing to bet significant funds that the Second Circuit could not reverse Judge Torres' decision. So I just like to bring you the information as I see it, and this was part of my reading today, and I thought that this was very helpful for anybody who was trying to distinguish whether this is FUD or there's truth. And now you have more of an understanding of what's going on going forward with the SEC versus Ripple XRP.